Okay. Good evening. Welcome to Empower You. I'm Betty Overstreet, the Executive Director. And just in case there's somebody new here tonight, there's a few things I want to remind you of. At the end of our speaker's presentation, we'll have a question and answer period. And if you have a question, if you would please raise your hand, wait for one of us to bring a microphone to you so that everyone in the studio, and especially the people online, can hear that question. Also, we are a free university. We operate on donations only, so towards the end of our class, we do pass around our little red buckets. And if you'd like to donate something to help us keep putting these programs on, we appreciate anything that you might give. Dan Raganol is the founder of Empower You. He's also the CEO of Frame USA. He's the one that provided this wonderful studio for us. I wasn't working with Empower You when they used to travel all over the city, but I used to travel all over the city to the classes. So I wasn't involved in all the work it took to do it outside of one place, but I know how easy it is to have it here. So we appreciate Dan doing that. Also, all of our classes, if they're in the studio especially, occasionally there'll be one or two that we can't live stream. As of last night, how many were here last night for the Armstrong documentary? It was good, wasn't it? You can see that on Amazon. If any of you missed it, you might want to go and catch it. But we couldn't live stream that one, but most of our classes are live streamed. So if you can't make it to a class, we do have them up online within a day, 48 hours at the most, and you can go and watch them. We archive them, so if there's a class last year that you didn't get to and you think about it, you can go and watch it still, and tell your friends to do that as well. Next, I want to just go over a few upcoming classes we have coming up. Next Wednesday, November 6th, keep in mind, Tuesday's election day. We know you're all going to go out and vote, so we avoided that night. But TED, Empower You does TED Talks. How many of you know about TED Talks? See, that was new to me. I didn't know about it, so I still haven't ever heard the real thing. But we're going to have it here. We've got 6 people that are going to talk on 6 different topics. Dan and I heard some of them last week. They were really good. I hope you'll come and support them. Some of them are stepping out and doing something like this for the first time. I know how unnerving that can be, so I hope you'll come and support them in what they're doing. And then Thursday night, we have Ken Williamson. He's going to be here. He's written a book on saying goodbye to Vietnam. And Ken was an Army photographer in Vietnam. And he has all these pictures and stuff that he eventually put into a book. So he's going to be telling about his experiences. He's going to be telling about the Vietnam people, what our troops went through, what he went through in Vietnam. So it should be a great class. And then on November the 12th, we have a story coming up about Reagan Tokes. She's a young woman that was going to Ohio State who left school one day, and I don't know the exact story. Dan knows all the story, I don't, but anyway, she was kidnapped and raped and murdered by a convicted felon who was wearing an ankle bracelet. And as Dan said the other night, we all think if somebody has an ankle bracelet on, that's kind of makes us a little safer, right? Well, it didn't happen for her. Her mother's coming up here from Florida. She's going to be telling the story about her daughter. There's also going to be another gentleman, Rob Fletcher, that's going to be here that night, and he's going to be telling us things that we can do to take care of ourselves. And then on November the 14th, we're going to have a class about the debt. And guess who's going to be our speaker that night? Our own Dan Raganol. He's a great teacher. If you, yeah, it'll be a great class because I can tell you every class that Dan has ever done, he spends months putting it together. He knows his topic very well. He's a good teacher. So put that on your calendar. And like he said, he's going to give you double credit. So you can't ask for more than that. And Dan, if you would come up, get your tickets out. We're going to give away our door prize.
We've got a fun door prize. It is matches our new part of our studio, the Betsy Ross flag. So that's pretty cool. Somebody gave that to us. It was who gave it to us, Betty? Don Hurd, the voice of Empower You, donated this to us, which is a great thing. So get your tickets. And you know, if it's a little big for you, just wear it as a night shirt or whatever, and a little small. But here we go. Let's have our guest draw a ticket. All right. This is the lucky one.
The winner.
How about 242? Right here. And your name is?
Sue.
This is Sue. Congratulations. Way to go. Let's thank Betty, our executive director. Give her a round of applause. Thank you. And how about, can I introduce you to the rest of the team? We've got Jay Grunke, our producer in the back. Thank Jay, please. And we've also got our treasurer and new title, he's also our popcorn manager, Bill Roll in the back, who does a great job. Thank you. Okay, so last night, we had a gentleman here who's an empowered citizen, meaning he attends a lot of our classes, and he had the sales tax petition. He couldn't make it tonight. He was kind of upset about that. I didn't get a copy of the petition. You don't have one, do you, Chris? Mr. Janis will be here, so I'm going to coax you to come back. He'll be in the back and let you sign that petition over the next couple of weeks if you attend the session, if you're so disposed to be against the sales tax. So a lot of you came last night to the movie. I really enjoyed the movie because it took me back to where I was back in that year 69. But it was so sad when the part about his wife coming on the screen saying he just didn't have any time for me. And that was really a sad thing. I didn't know anything about that, but it was tough. But I was glad we could do it. Just a couple things before our first speaker. I've got a homework assignment for you tonight. I'm going to give you when you leave. I haven't talked at all about the impeachment for good reasons, but and maybe our guest will talk about this, that one of the areas where impeachment was talked about by Alexander Hamilton and our founders was in Federalist Papers number 65. I'm going to pass it out to you at the end of the night. It's 4 pages. It's not a particularly easy read, but I'm going to challenge you to try to get through it. This is kind of a summation about what was said by Hamilton, which is kind of obvious to me. Hamilton warned that the process of impeachment might become political, causing factions to polarize further away from each other in their defense or prosecution of the impeached individual. There was also a notion that the Supreme Court should judge the impeachment, and Hamilton said under no circumstances should that happen because of the small size of the court. It should be handled by the Senate. But I'll give you this document. I encourage you to try to get through it when you get home. It's kind of fun. One of the things we've talked about in the class is the Port Cincinnati's forgiveness of property tax money to FC Cincinnati. I've talked about it a couple times. Still, nobody's been able to tell me how much money that involves, how much property tax that could have been paid that wasn't paid. Maybe one of our guests will know. But yesterday I just got so curious I decided to send them a public records request asking them how much money they've given away. And as soon as I get the answer, I'll let you know. They are what's called a quasi-public institution, which most times means they think that they don't have to answer requests from people like me. So I can't wait to see what happens, but I will sure let you know. A couple other things. Betty said, we've just got some fun classes coming up. And we hope to reschedule the Dr. Epstein Google class for the Tuesday before Thanksgiving. For those of you, we had to cancel because he was in the hospital. Chris Gonzales, gosh, I've known for a while, and there's just so much I could say about him. I was thinking about printing out a bio, but I really didn't think I needed to do that. A former City of Cincinnati Council member, Commissioner Hamilton County Commissioner for 8 years. And I thought most about Chris when I heard about the commissioners keeping the tax that we as citizens voted for a 5-year period, because I remember like it was yesterday, it's what I'm calling hashtag the promise. I remember Chris and Greg Hartman saying this tax will go away. And I remember so many people saying there's no such thing ever as a tax that will go away. And I think we found out what the answer is. I'll be interested to see what Chris says about that. And mostly I'm just interested, Chris has been out of the spotlight for a year or two, and I just wanted to let him fill you in on what he's been up to, what he's been doing before our first guest. So Chris, come on up. Let's give him a round of applause. Great. See, everybody, when they come to Empower You, is a winner. While Chris is passing that out, I just have one other thing I wanted to talk to you about. This document, this piece of artwork over here, I'm running a little contest for what it is, why it's up there. There are sheets in the back that say, what is this? If you give it the right answer, there might be a big prize for you. And Bill Roll has the entry forms in the back for what this is. With that said.
Oh, just 2 more left right there. Thank you very much. Thanks for having me this evening, Dan. Always appreciate your leadership. I just want to thank the Empower You folks. I look back to our founders. I remember the quote that someone came up to Benjamin Franklin after the Constitutional Convention. They're like, you know, what happened? He's like, well, you have a republic if you can keep it. And I think we can keep it if we have an educated public who understands, you know, the basics of what America is built on and our foundations and the Constitution and our government. And it's seen today in just electoral college discussion that we've had that, hey, they want to get rid of it. And that there was this great graphic that showed the United States, which basically all red and 2 little blue dots of Los Angeles and New York that would overturn the rest of the country that was red based on population. And to me, it's the wisdom of our founding fathers and the Constitution that I think is so critical. And Empower You, you guys continue that education and making sure that the public understands what's going on in government, what's going on in society, you know, so that you guys are well informed and educated so that we have a government that can continue to go on for another 200 plus years. And so I'm very grateful for you doing that and opening up your business and this great facility and putting it on the internet for folks to listen to. Because it is so important, especially when you see some of the polling right now that millennials, I think the recent polling show that I think 2 out of 3 would vote for communism. When you start hearing those things, it frightens me. It frightens me and the future of my children. And it's really important that we have people out there learning and understanding what our government does. And that's, I've been a student of government for my whole life, growing up here in the greater Cincinnati. From my first time I caught the bug back in high school. I went to this high school called Moeller High School, and I had an opportunity to take part in student government and other government activities, and had an opportunity to go down to Cincinnati City Hall for a week when I was a junior in high school, and I participated in this youth and city government program, and I loved it. I was like, this is awesome. You know, this is learning about, you know, just how government works and basically at the local level of your income tax, what you're paying your taxes for, you see every day when your garbage is picked up. You know, when a pothole is filled, hopefully, sometimes that wasn't happening in the city of Cincinnati. It was just frustrating. But I was like, this is incredible. So I came home. I'm a junior in high school, and I told my parents, I'm like, I want to be in government. I want to run for office. And my dad, who was an engineer for 30-some years, said, that's great, son, but you should get a real job first and make sure that you can provide for your family and your children and get a roof over your head. And you can do that on the side, but really focus on making a living. And that's what I did. I became an engineer, and I'm still an engineer today, 24 years with General Electric Aviation. And just from a standpoint, to me, politics is something that I feel so passionate about. as I've been given so much growing up in this community, that I want to give back to make sure that my children and their children and your children and grandchildren have the same opportunities I had here. And that's why I've decided to run for state representative in House District 28, which is you're in right now. House District 28 stretches from a little bit of Springfield Township, Forest Park, Green Hills, Springdale, Glendale, Evendale, Sharonville, Montgomery, Blue Ash, Deer Park, Reading, Sycamore Township, Madeira, kind of across the top part of the county from the center over to the east side. And that election is next year in 2020. And so a lot of folks are kind of like, well, why do you want to do state representative? Why do you want to go up to Columbus? And there's a couple of reasons. One I've kind of spoken to already. This district is my home. I grew up here. I went to high school here. My parents live in Sharonville, which is kind of ironic. They live in Sharonville, but on the Butler County side, because my dad didn't want to pay all those taxes in Hamilton County, so he stayed across the street in Butler County, still in Sharonville, which is kind of funny. But also, where I took my first job, one of my first jobs was working at Bethesda North Hospital in Montgomery. And then now working for GE in Evendale and Springdale, and raising my kids here in Glendale for the past 8 years. Also have a lot of family in the district. I actually have relatives on Evendale City Council and Reading City Council. And to me, it's that connection and that family that says this district is my home, and I want to make sure that it's well representative in Columbus, that we're actually doing things up there that are going to be effective in helping our district improve. Because there's a lot of needs, as you'll know, as you see in the newspaper every day, and a lot of issues that is being decided up in Columbus that are now being handed down from the federal government. I see our state Supreme Court Justice Pat Fisher. My gosh, sorry, Pat. Too many Pats. Pat Fisher's in the back. So Pat you should have a class with him on the Ohio Constitution. So that man can come in and just do a great class on what we're doing, but just important of how that Constitution affects the state of Ohio. We are facing issues at the state level from education, gun control, Medicare. I mean, things that affect your daily life, taxes. We spoke a little bit, Dan did, about the sales tax that just got passed from the county commissioners. Just a real quick, short blurb on that. You know, we fought really hard when the Union Terminal came in with Music Hall to do an icon tax, to really keep it in perspective and really look at what was the need, how much did they really need, you know, how do we make sure that it's just right sized, make sure that there's some deadline on it so that it does expire, and then make sure that it is a vote of the people. Those three components, I think, are critical to any tax. We do it with our property taxes. Property taxes are voted on by the people. They last for about 3 to 5 years, and it has a specific purpose. You know, going to seniors or going to children, it's a specific thing that you know you're voting on. That's the same for sales tax. And we did that. We put it on, and technically, it really does expire on March 31st, believe it or not. Unfortunately, the current county commissioners, the three of them, unanimously put in that a new sales tax that will extend that quarter-cent sales tax starting April 1st. So that is what's in effect, and that's why people are going around trying to get petitions signed, because if we get 34,000 signatures in 30 days, we have an opportunity to put it on the ballot in March to vote it down, or at least have a vote on it. And I think that's what people want. And I don't care what political spectrum you're on. I think people agree that you should have a say in how much you're paying in sales tax, and not just get something that's shoved down our throat that we really, and honestly, when you look at the county budget, they're saying they're about $20 million deficit. This is going to bring in $40 million a year. What are you going to do with that extra $20 million? I tell you, they're going to spend it, right? I mean, Ronald Reagan said, government always finds a way to spend your money. And unfortunately, I think that's some of the problems that we're seeing with this sales tax. And I would urge you, if you can, to please sign that petition so that you have a voice in being able to say whether or not you want your sales tax to continue to be at that quarter cent. So from a standpoint of issues that are still important, education is another one that we really need to look at. And I think looking at some of the polling on what the millennials are saying, we need to do a better job educating our children on civics, in our democracy, and on our, you know, what our government really stands for, the republic, you know, to be able to go in there and so people understand, you know, the responsibility they have to keep this republic. And I think that's something very important that we should be looking at within our public schools. And also in regards to how our schools are doing. We're paying a lot of money in our property taxes. I talked about property taxes earlier. If you look at your property tax bill, when I was county commissioner, everybody would say, man, your property taxes are killing you. I'm like, I get it. But if you really look at your bill, 80% of that is your public schools. So if your property tax bill, over 80% is going to your local public school district. They need to be held accountable, and they need to make sure that they're providing, a good education. And when you look at the report cards, especially in this House district, it ranges from school districts that have A's to D's. Well, why? Why is that? Why can't we figure out how the schools that are getting A's are doing so well and leverage that to help out the schools that aren't doing so good? And we have some examples. Deer Park School District actually went up from I believe a D to a B. And so it's like, what did they do? What did they put in place that made them go to that jump? And why can't we do that now over another school district that's not doing so well? I mean, it's that best practice sharing that we do within businesses and private companies, we need to be doing within our educational system as well. So that's just another critical issue. The other key one is jobs. We have the Trump economy going on right now, which is incredible. We need to keep that going. We need to make sure that we don't have job killing regulation passed in Columbus. I feel like the administration in Washington, D.C.'s rule of every regulation you pass, you cut to, that should be applied at the state of Ohio. Same thing. You should make sure that if something's going to go in, that you reduce that burden on families and businesses, because otherwise, I think our economy will start grinding to a halt as you get more red tape in it. And in fact, at the county, we created a red tape position to cut some of that red tape so businesses could get things done quicker. And then also the last kind of issue I'll talk about briefly is public safety. Nobody wants to live in a community that's not clean and safe. They don't want to put a business there. They don't want to put a family there if they don't feel like there's, safety. And to me, public safety is crucial in making sure that our first responders, the women and men who every day put their lives on the line to protect us, have those needs that are necessary met through state legislation, through our 911 center at the county. We have a great 911 center, one of the best call times. But we need to make sure that it's still functioning and up to date and has the latest technology so that we can do things. And that's the Alert HC. I don't know if you, in Hamilton County, there's alerthc.org. If you go to that, you can sign up and get actual personal messages on your cell phone. If there's a tornado, a flood, any type of public safety issue, those type of things are helpful in order. In fact, unfortunately, the Plush tragedy that took place down in the city of Cincinnati, if their cell phone, the children's cell phone was in that device, they could have contacted the parents to be able to help out to find out something was wrong sooner. And that's what this Alert HC does in Smart 911. And I encourage you all to sign up for that because that is a great tool that can help prevent, some tragedy from occurring in our community. So, and Dan said I could have like an hour to talk, but I'm not going to take an hour. I could never do that. Trust me. I know Justice Fisher knows that I'm not a big speaker, but I do want to thank you all for the opportunity to come out tonight and give a little update of what we're doing. This race is a winnable race. This race it's in competitive district. For the 2 terms before, Representative Jonathan Deaver had it. He only lost by 56 votes last year, 56 votes. I actually got over 685 more votes in this district in my commissioner race in a pretty bad year for Republicans. So we definitely have the votes out there. We just need to make sure that they get out and vote in 2020. There's a lot of races on the ballot. A lot of excitement's going to be going on, but we got to make sure that we show up and we make our voices heard because you know what? It's a republic if you can keep it. So thank you very much and God bless.
Thank you. Good seeing you. Thanks for coming. And I guarantee you this will be the best pen you've ever
So if you look at the pen, we had about 2,000 of these pens left over from our last race. And my mom and dad took razor blades and scratched off so that we could keep reusing them for going forward. So I'm a very fiscal conservative. I don't know if you noticed that or not. Thank you.
That is a good story. I mean, I've still got some of these from 4 years, years ago. So thanks so much, Chris, for coming in. Good to see you. Let's go to our main topic, which is going to be great. Joseph Ashbrook is president of the Cincinnati Lawyers Chapter of the Federalist Society. That was founded in 1982. The Federalist Society promotes the principles that the state exists to preserve freedom, Separation of governmental powers is central to our Constitution, and it is the province and duty of the judiciary to say what the law is, not what it should be. Mr. Ashbrook grew up in a small manufacturing business and also worked in corporate America before studying law. He was editor-in-chief of the Virginia Law Review and currently practices law at his own firm, serving as an outside general counsel and providing litigation services for businesses and individuals. Joseph Ashbrook.
Well, Dan, thanks for having me. Chris, really appreciated your words. You got a republic if you can keep it. Well, there's a lot of good folks out there that are working really hard to keep it. And I think for us and to our children, that's a promise that's worth it for all of us to run hard after. Well, good evening. As Dan said, my name is Joseph Ashbrook, and I am the president of the local chapter of the Federalist Society and an active member. But the views expressed here tonight are ultimately my own. Unashamedly so, but they are my own. Now, I'm going to hit on some topics that I was asked to discuss, including marijuana, guns, and immigration. But tonight, our ultimate focus is going to be on the ultimate topic. Who decides? You decide. Something special has been going on in America for the last 30 years that's worth talking about and it's worth fighting for. And the Federalist Society is right at the heart of it. But we can't really understand what that is until we remember who we are. Our founding fathers were not perfect, but we don't have to pretend they were perfect in order to honor what they did. And in 1776, a man of deep contradictions and real failings, but still a real man, picked up his pen and under the pain of death wrote with power, "We hold these truths to be self-evident, that all men are created equal." Equal. Who we are as Americans is children of that promise. And our story, our history, has largely been our struggle to live up to that. That's real. Slavery being a very salient example. But the things that the Federalist Society has been fighting for in America are also part of that story to help us live up to those words that Mr. Jefferson wrote. Limitless, endless, indefatigable are the human capacities to rationalize why I should decide, but not you. You're not the king. You weren't born into nobility. You don't own land. You didn't go to as good of a school as I did. You're black. You're poor. You're a woman. You grew up in the ghetto. You grew up in the country. You're white trash. You're ignorant. You're wrong. When the most powerful nation on the face of the earth looked at the founders and said, "We're the brain, you're the hands and feet, go do what you're told," they said, "No, we matter too." And they changed the world. America is exceptional, and America is exceptional because for the previous 10,000 years of human history, nobody in this room mattered. And now, your voice counts as much as a past president of the United States. One person, one vote. We did that. America did that. We're not perfect. But in the ash heap of human history, America's the phoenix. And for the last 30 years, the Federalist Society has been waging a war of ideas in the lawyer class to help us all shake off a little bit of that old world ash from those wings. The Federalist Society was founded on the principles that the state exists to preserve freedom, that separation of powers is central to our government, and then it is emphatically the province and the duty of the judiciary to say what the law is and not what it should be. Now, our most famous of those principles is probably the last one, but I think they all work together. You've also probably heard of the terms originalism and textualism. Now, there's various strands of those, but they're not mystical, and I'll sum them up like this. What's the law around here? The law is what the people's representatives put on the page when they put it on the page. And those principles are very similar to the principles of the Federalist Society, and that ultimately work together for the same thing. And the idea that the role of a judge is not to say what the law is, but what the, is not to say what the law should be, but what it is, isn't even really about the judge at the end of the day, it's about you. Because to the ultimate question, in America, where does supremacy ultimately lie? It lies with you. And that the Constitution codifies as law. And in the American rule of law, we're all better off. As a jumping off point, let's look at the words of Mr. Jefferson in their fuller context in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Now, can anybody catch the subtlety after the famous lines of these rights, life, liberty, and the pursuit of happiness? What is the purpose of government according to that, according to the text? What is the purpose of government? Why does government exist? To secure the rights, to secure the people's rights. And what you see in the Constitution is that part of the way our founders secured those rights and preserved freedom was the diffusion of power. Let's look at the Constitution, the very beginning of it. It starts with "we the people," but I want to direct your eyes to the very last purpose statement. It's to secure the blessings of liberty to ourselves and our posterity. That echoes the words of Mr. Jefferson in the Declaration of Independence of the purpose of government here, or of our Constitution, is to secure those rights. And as I said, we're going to talk about it in a minute, we have to with supremacy. The part of the way it does that is the diffusion of power. But I think, in fairness, and to fully understand the issues, we also have to mention that I want you to look at the other purposes too, and appreciate there's some tension here. There's some natural tension. So it's not just to secure the blessings of liberty, which when you think of states' rights, individual rights, who decides, I decide, that diffusion of power, that certainly is inculcated in that, but there are other purposes here. To establish a more perfect union, to provide for the common defense, to promote the general welfare, and then of course to secure the blessings of liberty. This was not our country's first attempt to create a national government. Can anybody tell me, does anybody know what we tried before this, what it was called? Yeah, the Articles of Confederation. Now, the Articles of Confederation created a particularly weak federal government that was ineffectual and included problems like the states overstepping the federal government in the area of foreign affairs. Can you imagine If we had all 50 state governments try to negotiate treaties with Venezuela, it would be a mess. So there really are benefits from a centralization. There are some benefits from a nationalization dynamic for us as a people that are real. And then it's important to fully understand the balance and the tension are real. So the way I like to think about it is the concept of unity and diversity. What the founders did ever since the time, so we live in very contentious times. I think everybody would agree with me like that. But ever since the beginning of the country and the founding in the colonies, the question has always been, the real most important pressing question has always been, is America too diverse to be one? And the answer to that is no, because we're unified around the principle of freedom. And there's great unity in that diversity. And when we look at the diffusion of power and federalism, I think you'll understand and you'll see some of the beauties of that. But when you look here, even at the preamble of the Constitution, you'll see some of the inherent tension between our unity and our diversity. Both very important, both very real. For every snake that says, don't tread on me, there's a snake with the colonies cut up and saying, join or die. Because what ultimately protects our freedom for our posterity is our collective effort. I don't think 50 individual states could have fought a two-front war in the 1940s and stopped imperial Japan and fascist socialist Germany. I don't think they could have. And so our collective interests, our national country, also protects our localized freedom. And because of the Articles of Confederation being weak, part of what they were trying to do and form a national, more perfect union was to be able to still get the balance right between an effective national government and the diffusion of power that preserves and secures the blessings of liberty for our posterity. Now, I want you to think about the diffusion of power. There is some disagreement on this, but I'm a textualist. I'm just going to tell you what I think from what I read the text, and I don't care. Diffusion of power works two ways, horizontally and vertically. You can think about it like a capital letter T. In the federal government, through the Constitution, power is diffused horizontally through what's called separation of powers within the federal government, but it's also diffused vertically in federalism. And largely what we're going to focus on and talk about here today is federalism. It's the idea that in our country there are 51 sovereigns. Really, but think about that as two sovereigns, or two levels of sovereigns. You have state governments and you have the federal government. Now, in the original construction, in the text of the Constitution and in the original founding, state governments today are still relatively similar to what they've always been in terms of the reach of what they could do, because they better approximate what historically would have been considered a sovereign, in that they have general plenary power to regulate all of human life. They're a sovereign. They have what's called, it's often referred to as a general police power. Whereas the federal government, not that way. The federal government, under the text of the Constitution, is a government of limited and enumerated powers. But the Constitution also contains a supremacy clause. Here's the way I want you to think about that. Under the text, federal power can't speak to everything, but where it does, it speaks authoritatively. Makes sense, particularly coming out of the Articles of Confederation context. The trick is that in the American experiment over the last couple hundred years, and particularly the last 100 years since the New Deal court, what the federal government has been allowed to do under the Commerce Clause plus the Necessary and Proper Clause has become so vast that what federal power can reach is probably 99.9, probably not 99 repeating, but 99.97 something. It's very vast. And we're going to highlight some of those tensions here when we talk about specific issues. So what you now have is federal power can't speak. Now, federal power speaks to almost everything. And where it speaks, it still speaks authoritatively. So now you essentially, instead of having two governments where they maybe speak to different issues, that's a local issue, that's a national issue, they're going to both speak to every issue. And it creates some tension. I think it creates fairly the right of the people to look at it and say, hey guys, what's the law around here? What's required of me? You don't agree with you. And ultimately, I mean, what's the law around here? And that's a very valid feeling. And as we talk about this, let me back up and make a prefatory statement I hope you can appreciate. Discussing legal doctrines and cases and issues in almost any area is like our forefathers coming down the Ohio River. Any area, any doctrine, any topic you're talking about, the reality is it's so deep and so rich, and there are rivers almost innumerable coming off every side of it as you're going down the Ohio River. And it may be terribly interesting, but if you're not careful, you're going down that river and all of a sudden you're in Hamilton on the Great Miami and you realize, you know what, I got to get back to the Ohio. So part of what I'm going to do as we're talking about these is try as effectively as I can to give you what I think is most important for you to understand of what's going on in the larger discussion with the ultimate question in mind: who decides? Two areas I specifically want you to understand and have in your mind that we're going to be talking about when we talk about specific areas, that in this world that we live in today, where federal government is authoritative, where it speaks supremacy, but it can also speak to everything. The two ways that I think are most pertinent in most areas today that effectuate and manage that interplay are called preemption and anti-commandeering. So I think most of you are probably familiar with the 10th Amendment. And I think the 10th Amendment, it shows textually the purpose of the vertical, well, textually it shows the vertical diffusion of power. Now, this is viewed today as largely it's viewed as a truism, meaning there's not any independent force that comes from the 10th Amendment that limits what the federal government can do. And I think a plain reading of the text from a truism standpoint is a pretty fair reading. There's no affirmative language in that provision textually that operatively necessarily limits the federal government. And so I do think there is something, at least to the plain reading of that, of realizing it's a truism. That doesn't change the dynamic of what the federal government can do through the plain reading textually, original public meaning, maybe, of the Commerce Clause and the necessary and proper clause. But it does clearly show that vertical diffusion of power. But I do think what we need to mention here, remember I mentioned anti-commandeering? So anti-commandeering, which is pegged to the 10th Amendment, is the principle that states are sovereign. Remember we talked about two governments, states themselves are sovereign. So by virtue of being a sovereign, federal government cannot tell the state legislature what law to enact, and they cannot tell the executive or tell the employees, officials, or folks of the state government to enforce their law. That's why they call it commandeering. They can't commandeer the state to do their bidding for them. One way to think about this is, okay, federal government, you want to make a law? Go for it. You go enforce it, but you can't make me enforce it for you, and you can't make me actually enact it. That's anti-commandeering, and it does play in some of the things we're going to talk about. This is the Supremacy Clause. This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. And in the world I mentioned that we're in today, the doctrine, besides anti-commandeering, if you remember that I said manages this, that we got to keep our eye on here, is called preemption. So just because Congress, so now you got two governments. they can regulate almost any aspect of your life. They can do it theoretically on the exact same subject, but let's say Congress does it. When Congress does it, you've got the supremacy clause. The doctrine that operates out of this is called preemption. And the question becomes, has Congress and what they did preempted the state and what they did? And there's a couple different types of preemption. One being express. They expressly say we're preempting something. Another being what's called field preemption, and another being obstacle preemption. The basic premise of which is, it gets incredibly complicated, but fundamentally where the federal government has spoken, it's supreme, and the states aren't supposed to poke them in the eye and effectively work against what the federal government is doing. But the federal government, in the canon of case law, the Congress doesn't even have to actually say we're preempting. And that's where the doctrines of field preemption, Congress says, the court says, that what Congress has done here, unless Congress says it, is so pervasive of a regulatory scheme, it's essentially occupied the field and the states can't speak to it. Conflict preemption is more of, there's an irreconcilable conflict between these laws, such as a citizen, I can't legally both comply with what the state's telling me to do and what the federal government's telling me to do. In that case, it's a clear conflict. The federal government wins, the supremacy clause says. So let's get into some specific topics and see how these are playing out. Marijuana. This topic, in my opinion today, you could care absolutely nothing about marijuana. Nothing. You could hate it. You could think we're compassionate to let people smoke it. You can think it has been a moral blight on civilization to have prohibited it. But this is an incredibly interesting intersection of federalism today in America and all those principles. Couple basic points. Marijuana. Federal law, there's a federal law that criminalizes marijuana with no exceptions. Now, states, as a matter of first principles, states that disagree, and we're talking about what can states do and not do, a state that disagrees and that says, we're not going to criminalize marijuana, we decriminalize it, or we decriminalize it, or we don't criminalize it for medical purposes, just the enactment of the law, I can't see how that could violate supremacy and be preempted, including because of the anti-commandeering principle. Especially because of the anti-commandeering principle. But as we look at and think, hey, what can states really do? We need to recognize that this falls within, remember I talked about that area of power that the federal government has grown since the founding, particularly the last 100 years. This falls directly in it. And one of the most important Commerce Clause cases of modern times is actually a marijuana case. Gonzales v. Reich. Now, and Gonzales and Reich, I'll call it Reich, the state of California passed something called the Compassionate Use Act. And a couple of ladies in California were using marijuana, that allowed for use of marijuana for medical reasons. And a couple of ladies in California were using medical marijuana for medical reasons pursuant to state law. And one of the ladies was even growing it on her own property, akin to you and I having a vegetable garden in our house. You cannot find a course of human behavior that is more intra-state than that. Note, catch the subtle distinction? The Commerce Clause power gives Congress the power to regulate interstate commerce, not textually intrastate commerce. And in the Rehnquist court, think 80s and into the early part of the 90s, the Rehnquist court had a couple of Commerce Clause decisions that said federal government can't actually do that, which led everybody in the legal community, including academics, to think, well, maybe Commerce Clause isn't dead and federalism isn't dead and the federal government can't do everything. So they thought when this case came along, I think there were a lot of pundits that said, you know what, I bet this is going to get struck down because you can't get any more intrastate than that. Answer, no. no, the federal government can do this. And I pulled out what I think is the pertinent language right to the heart of the issue. The defendants, here the ladies, when you're on appeal, they technically have different titles, but for your purposes to understand, these are the ladies who were using the marijuana for medical purposes. The defendants argue that the Controlled Substantive Act, which is the act that we'll talk about in a minute, its categorical prohibition for marijuana as applied to the intrastate manufacture and possession of marijuana for medical purposes pursuant to California law exceeds Congress's authority under the Commerce Clause. And if you look at my citations, you can see the numbers 15 and 33, this means these are on way different pages. The second part after the ellipses is really the conclusion, but I think this sums up what I think is pertinent to set up some other dynamics. Our precedents foreclose that claim. So the federal government, under our Supreme Court precedent, under the Controlled Substances Act, clearly has the authority to regulate these ladies' purely intrastate use, growth, possession of marijuana. And the reason they do that, the quick and dirty, is that this intrastate use is viewed as possibly having an effect on the larger interstate market. But the reason I wanted to point this out, and including the last statement, that our precedents foreclose that claim, is that ultimately what they're not saying is the text of the clauses forecloses that claim. And there is a very subtle dynamic going on in the law, and it's probably going to go on for the next 30 years as the judiciary continues to grow and be filled with people who have a textualist commitment. There's a tension between, you've probably heard it in the press, the concept of stare decisis and the text of the original Constitution. Now, the term stare decisis in Latin just means to stand by things decided. So, in this case, there's a depression. There's a New Deal. I don't know, I tend to think it's an old deal and it's a very bad deal. But the New Deal era, there's a case called Wickard v. Filburn, which is essentially about the regulation of wheat. It was an agricultural product, grown and intrastate, that the Supreme Court said, yes, through the Commerce Clause and the Necessary and Proper Clause, we can regulate that. It's very easy as a jurist when the peg you're standing on is that precedent to then say, I don't know, this really isn't that different than that. If they had the power to do that, then they clearly have the power to do this. That's what's going on there. So I think there's a really important dynamic that the realist in me, no matter how much we'd like fidelity to the text of the Constitution, I think that the erosion of stare decisis is probably going to be incremental at best for the foreseeable future. But I do think in the progress of freedom that it's very possible, if the goal is ultimately, which it should be, to protect and further the institutional legitimacy of the court, logically, there's a lot of power. There's a lot of real power in recognizing that the best way to further the institutional legitimacy of the court is fidelity to the people's text. And there's the dynamic of saying there's a rule of law value in having things decided as well, which is terribly important with stare decisis. But in this case, where the potential tension would be between the text of the Constitution and the former precedent of the court, you're really not going into a dynamic where you're perpetually undeciding things. You're just making a choice. What are we ultimately standing on? What the court said last time, or what the text of the people's law says? And I do think that it is possible in the next 30 years in America that you could see some continued change in that dynamic if the people continue to drive the fundamental power of the logic that's right, that the people's law are the words on the page at the time that the people's representatives put it there. But that's important to keep in mind. I think one last thing I want to point out with this is that Justice Scalia actually concurred. He wrote a concurrence in which he said, majority, you're wrong that this is the Commerce Clause. It's not the Commerce Clause because this isn't interstate commerce. It's a necessary and proper clause, but he concurred. And there's a sense to it, one of the main arguments against the Federalist Society ideas, well, I think the ideas of progress of mankind, but one of the main arguments against it is the judges and the people who push these ideas, that it's all about the text, it's all about the text. They push that idea when they can get a result that they want that meets the policy, and then if they don't like it, they do what they want anyway. Now, I think the answer to that challenge is pretty simple. All the more reason for all of us to culturally emphasize the importance of fidelity to the text. But I wanted to point this out because we're going to come back to it in another thing later. One of the main street arguments that people make to try to undermine the legitimacy of this stuff is they point to things like this and they'll say, well, Justice Scalia just didn't like drugs. So ultimately what he said was, when it's time to stick it to the people smoking marijuana, forget about the textual limitations. And it's worth pointing that out because that is real to understand that dynamic. Justice Thomas was still in the dissent. And he has for a long time, I actually read a recent Supreme Court opinion where he still cited to himself in this case has had a long, consistent, principled argument and position his entire time on the court that the Commerce Clause to limiting textually the federal power under the Commerce Clause is a necessary proper clause. All right, so enough inside baseball, although I think it's important as a practical matter on a high level to understand what's going on. Let's look at a specific example, and we're going to actually look at Ohio law with respect to marijuana. So once the federal government has the power to regulate it, that's Reich, then the question becomes, what has Congress said, and is the state law then preempted? So let's look at the text of the Controlled Substances Act. Now, the act is a little more complicated in how it operates than what I put on the board, but I don't think those differences are material, and I wanted to put a laser-like focus on the text for what matters. So the Controlled Substances Act, now what Congress has said, says, it shall be unlawful for any person to manufacture, distribute, or dispense, or possess with intent to manufacture, distribute, or dispense marijuana. And as you notice, that's with an intent, the possession there is with an intent to distribute. There's also what's called a simple possession requirement. That's just someone who's not going to distribute it, but they're just possessing it for their own use. It's also unlawful, but the penalties are less. But it does have a simple possession requirement. So the way to think about this is the federal government, from a policy standpoint, no, from a law standpoint, is actually saying you cannot, it is a crime in our country, a crime to distribute, manufacture, or possess marijuana. Now, as I mentioned before, state laws can be preempted even where Congress hasn't explicitly addressed the matter. But here, in the Controlled Substances Act, they have actually addressed the matter. So let's see what they said. This is the actual language of what Congress has said. And with my paraphrase at the beginning, because there's a massive paragraph before it. And state law is preempted by a provision of the Controlled Substances Act, where there is a positive conflict between that provision of this title and the state law, so that the two cannot stand consistently together, cannot consistently stand together. So I think a very practical, common sense, plain reading of the real language of that is, Congress has spoken and said, these things are criminal, they're illegal. It's made a value judgment. And the language before this is somewhat helpful, but I don't want to drown you. Congress is basically disclaiming that they're occupying the field, except unless there's a positive conflict between a provision of state law. In other words, if you were creating a system, this isn't a statement about Congress's intent, just a practical statement. If you're creating a system where you want to criminalize a drug, you probably want the states to also criminalize it too if you want to have the effective enforcement. So a practical way of thinking about what they're saying between that is, look, states, if you want to regulate it too, you go ahead and regulate it too. You're not foreclosed from doing that, but a law is preempted if they can't stand together. Now, with respect to Ohio, because we all know, Ohio has legalized marijuana in the medical realm. What can Ohio do and not do without potentially running afoul of preemption? Well, as we mentioned with anti-commandeering, the federal government can't force Ohio to say marijuana is illegal, and it probably can't force Ohio to enforce federal law that it's illegal. Kind of the point of, hey, okay, federal government, you want the law, great, you go ahead and enforce it. But according to the terms of the statute itself, state law can't conflict with the provision of the CSA. Now let's look at Ohio. And the punchline, I hadn't looked at this until I started preparing for this talk. The punchline for me is I think there's a real tension in Ohio as to what's going on in the plain reading of that law in the preemption provision. This is from the website, the official Ohio website through Commerce, related to the marijuana control program. Frequently asked question: how is the number of cultivators determined for your medical control program? Well, we consulted industry experts and reviewed comments from the public regarding the potential patient population and supply of medical marijuana, as well as the number of cultivators needed to meet the demand. The proposed number of cultivator licenses will promote competition and proficiency in meeting the demand for medical marijuana in order to provide patients with a safe, consistent supply of medical marijuana. Now, translation. Now, this may be, and we're going to get to it a little more in a minute, we're promoting, fostering a safe, reliable, efficient supply of marijuana for people to manufacture, for people to possess. And that goes beyond just legalizing it. It actually arguably promotes and fosters what federal law has said is prohibited. There we go. Hopefully we don't lose it. Further, and I'm going to read this to you because it's too small, unfortunately. However, this is from the same website, which is Ohio's official resource for the medical marijuana control program. We're going to teach you. So we're going to tell you and teach you and help you obtain medical marijuana. First, the first step, we're going to see a physician. The first step to become, I'm going to read this to you under see a physician. The first step to become a medical marijuana patient is to establish and maintain a bona fide physician-patient relationship with a certified physician. And if that's not enough, we're going to help you get registered, and then we're going to help you find a dispensary. Last bullet point. And if you need it, find medical marijuana near you by clicking here. And if anybody has any issues or any problems, call our helpline. The issue, the real tension and issue, this is a 50,000 foot perspective for someone who really honestly doesn't have a dog in the fight. Federal law has said, has made a value judgment that the manufacture, distribution, and possession of marijuana is criminal. In this program, the state is affirmatively enabling, fostering, providing, and helping the distribution, manufacture, and possession of marijuana. Now, this may be good governance. It may be terribly compassionate to let sick people use marijuana for medical reasons. And if you're going to do that, it may be good government to assure a supply that's consistent and assure a supply that's safe. And it may be good government to help them get it. But you know what else it is? It's absolutely fostering what federal law prohibits. So now if this was actually litigated, there would be really smart lawyers. There's an art there'd be really smart lawyers that would take the specific provisions of the law, and it would be, well, this one is, or is that, this part maybe, that part's not preempted, that part might be, and it would become incredibly complicated. But I gotta say here, for me, it's an entire program, and the entire program is to foster what federal law prohibits. So I think, under pure analysis, I think there's some real tension there, and it's potentially problematic. If Reich is right, meaning if Reich isn't right, then you can have a purely interstate market that's created where the government does good governance, disagreeing with the federal policy, and promotes what it thinks is in the best interest of its citizens, even different from the federal government. But if Reich is right, I think this is potentially problematic. Now, there are smarter people than me out there. I'm kind of a, if it looks, swims, and quacks like a duck, it's probably a duck kind of guy. And I think marijuana in general is such an interesting intersection of federalism principles that our local chapter of the Federalist Society is going to do an event in March where we're going to bring in one of the country's current foremost academics on this subject, who's largely hung his career lately on the federalism implications and dynamics. So if you are interested in this stuff and continued discussion of it, let me know, and we'd love to have you join us for that. But I think for me, the look, swim, and quack like a duck, Joey Ashbrook, I tend to think if Reich is right, what we're doing right now in Ohio is problematic from a preemption standpoint. I personally don't think Reich is right along the lines of Justice Thomas's analyses. However, I'm not 5 Supreme Court justices. Bump stocks and guns. Now, we all know about the series of tragedies in our country, and what I'm going to talk about isn't going to take any position on the merits of what we do about that. It's just a forensic analysis to highlight some of the key supremacy hinge points for you to be aware of. As we're all aware, now we talk about local, state, federal. The city of Cincinnati enacted a ban on bump stocks. A Hamilton County judge essentially struck that down for being in violation of state law. Now, localities, if you read the Constitution, I love local government, local control. Localities, there's no place for them explicitly in the constitutional order. They're a subdivision, a function, a product of the state. And so if they violate state law, ultimately, even though in Ohio we have strong deference to home rule and the ability for local control, the state still retains ultimate power. Cincinnati's bump stock ban violated state law, so it got struck down. What's terribly interesting about this is that while that case had not finished its appeal cycle for the law to be fought about within the Ohio appellate courts, the Trump administration made a change in the law through the ATF with respect to definitions, really important. So in other words, I'll give you the quick and dirty. Congress can regulate this, but Congress isn't taking any action with this. The city of Cincinnati says, we're going to take action. We're going to lead the country. These perverted originalists are killing all our kids. We're going to stop this. Hey guys, you can't do that under Ohio law. So it's struck down. Yeah, we can. Okay, we'll fight about it. Before that ever gets fully settled, Congress still doesn't do anything. The Trump administration, through the ATF, changes. There's a statute that's always been existing on the book. You guys read in the popular press, probably understand this. Fundamentally comes down to the definition of a machine gun, which has been regulated in America forever. The ATF changed the agency's interpretation of the substance of what's considered a machine gun from what it had been previously, even in the Obama administration, to now what it is to include bump stocks, which it didn't before. And so with that change of agency interpretation, boom, it took the issue off the table. Bump stocks are illegal. We don't have time here tonight to go into the discussions about agency, but separation of powers and federal agencies are an incredibly Agency law in general is an incredibly important area when you think about the founding, because you read that document, they're not in there at all. And they're terribly important. I think it's worth mentioning that there is some litigation going on right now in the Federal 10th Circuit Court of Appeals, where there are a lot of folks, including an organization called the Cato Institute, which is known as a national libertarian organization that often files briefs consistent with most of the folks in the Federalist Society orbit, which is a big tent. They're arguing against the president's administration, and they're saying, you can't do this. There's a couple aspects of problems with it. There's the retroactivity, arguably, but there's also the dynamic of ultimately, can the agency just change, their interpretation, but the fundamental impulse is that it's Congress's job. I just got the light. Is that a question, or are we running out of time? Oh, okay. That's okay. Hopefully the light's coming on for all of us now. Yeah.
I think we've got about 20 minutes, but I had a question.
Yeah.
So the bump stock law got ruled in Ohio. So why didn't the city of Cincinnati you can have 100 grams law get ruled out in Ohio?
You talking about drugs?
The marijuana,
marijuana?
The Cincinnati marijuana law that says you can have 100 grams of marijuana on your possession. Why didn't that get thrown out of Ohio?
I am not
Or has it just not been challenged?
Give me well, it's possible. I'm never shy about reasoning on first principles, but to be transparent, I haven't looked at that specifically, so I can't say for sure. Okay. It was 100 grams of marijuana. They said you can have up to 100 grams.
Yeah, in the city of Cincinnati now, anybody can have 100 grams of marijuana on their possession, and the chief of police in Cincinnati doesn't know if he should follow Hamilton County's law and not arrest them, or if he should follow the city law and not arrest them.
Yeah, I think it's incredibly complicated. There's an overlay in Ohio where Ohio has some deference to local control and home rule in certain circumstances. I know enough about that to be dangerous to know that it exists, but I'd have to pull up all the language and look at the provisions of text. So I wanted to just give you on the bump stocks some of the supremacy hinge points, and including right now, it's a really important agency-related question, things that dorks like me care about and that we geek out about that's really going on. But what I really wanted to talk about with guns and the larger issue is to take you back, because I think this is the most important point, to the meta point of what's going on in America and who ultimately decides. I want to take you to the language of the Second Amendment. And I've also included here a reference to the Supreme Court decision in Heller, which is Justice Scalia's opinion with respect to the Second Amendment and our rights, striking down a District of Columbia prohibition regulation on a handgun for defense in your home. And I've been talking about, and I talked earlier about textualism and originalism, and I averred about the progress that we've made. And I talked about something special is going on in America. I think it's special because the judges in America, as a matter of course, are now far more likely to start with the text than they were before. And the arguments are to arise from the text, at least first or foremost, than it was before. And I think that's progress. Read this case for many reasons. It's terribly long, maybe give it a whole day. There's a lot of things that you're not going to fully understand because they're legal type jargon that it's helpful to go to law school, but I give you my phone number and my email at the front of this slide deck. Feel free to call me or email me. I'm happy to help you get through any of those. What I think is most important about this decision is that when you read both the affirmative opinion of Justice Scalia and you read the dissents, what they're fundamentally arguing about, particularly Justice Stevens' dissent, is the text. And the fact of what's going on in that opinion itself is a huge advancement for the progress of freedom in America, because the ball game, the playing field, is fundamentally the text. And circling back to my Reich point that I made about Justice Scalia, he gets a lot of flack for this. Similar to the dynamic of he wanted to find a constitutional right that didn't exist because he values guns. He's a gun guy. He hates marijuana. He's about textualism, but he hates marijuana and he hates guns. So he gets a lot of flack for this. I think ultimately you need to read it and reach your own conclusions. Now, I had read a lot of commentary about this case, but I honestly hadn't read it until I was preparing for this talk. I thought, yeah, I probably better read Heller. And I think starting from the language of the Second Amendment itself, so now we're going to do a textualist exercise with everybody in the room. You're now the judge. You decide. You can read, you can think, you can reason. So you could be a judge. One of the great arguments against Justice Scalia's decision is that the right to keep and bear arms from the founding was tied to the dynamic of military service in the militia. Just everybody go ahead and read that. Now, you're not patently crazy to hold that opinion because the words, a well-regulated militia and the prefatory clause are there and provide some overarching shaping about, hey, what's going on here? But I also think that a lot of the pot shots are deeply unfair. Does anybody see can anybody tell me what they think is the operative legal language in this provision? What imposes the legal whatever? Yes. Yes. Anybody else?
Well, hold on. Could you speak in the microphone, please?
There's no real condition placed on the right. I mean, they're talking about the militia,
Yeah.
but it doesn't say the right of the
Yeah.
people
Yeah. Yes.
when they're in a militia or as part of the militia.
Yes. Yeah, it's not
It says the right of the
conditioned.
people, period.
Exactly. Yeah, it's not, the language is not expressly conditioned on it. So when folks get all bent out of shape of, it's about military service, the kind of the new language that's starting to emerge is perverted originalism. I guess when you're on the wrong side of history, you got to argue something. It's perverted originalism. It's not, there's no conditional language in it. So once you accept that, read the opinion. All you got to do is Google. This is a citation in the U.S. Reporter for where it occurs. You Google 554 U.S. 570, there's going to be a website that can actually get you the text of the opinion. When you read it, you make your own conclusion. But this is the point I want to make. Back to the stare decisis point I made before. There were Supreme Court cases, without getting into the dynamic of what's really the law and what's dicta and not. There were Supreme Court cases previously that averred that the right to keep and bear arms was tied to militia service. It's in the text of Supreme Court cases. Now, the way in his opinion, you'll pick this up, Justice Scalia deals with that is to say, this is the first time we've ever, this is the first time we've ever actually done a textual analysis of the Second Amendment. But I think implicitly the dynamics that are going on there, however he navigated the challenges of institutional legitimacy and stare decisis and all that, fundamentally what's going on here is the Supreme Court there had been a practice in America for 150 years where we were regulating guns. And the limits on that were largely put on the will of the people through their elected legislators. There are Supreme Court cases that tend to tie this to guns. So it's not patently nuts for people to say, oh, it was tied to the militia. However, Scalia says, let's do a textual analysis of all these words. What's the law around here? The law around here is what the people's representatives put on the page when they put it there. So however it gets there, there's definitely an intuition here. If you agree with his ultimate argument between Justice Stevens, on the probatively, what is actually these words mean, we're siding with the fidelity of the text over what the Supreme Court might have previously averred. And I think that's an important subtlety, but with the right itself, you need to read the case and ultimately reach your own conclusion, which you can, about what these words really meant. When a judge is doing that, it's a lot like what we'd say in law, a factual determination. What you're doing is saying, well, here's evidence on this side here's evidence on this side that he slipped on the rug. Here's evidence on this side that he didn't slip on the rug. He tripped over his own 2 feet. And then the decision maker, the factual decision maker, looks at all the evidence and determines based on which of the evidence is more likely, boom, we have a finding. When judges are determining what this meant, the law is what the people's representatives put on the page at the time, then the ball game becomes, well, what did it mean back then? The original public meaning, what did it mean when they did it? So you're looking at language of the text itself, like I just pointed out, the conditional nature of the prefatory clause that it's not, but also what was in the water then? How were they using these words and what did they mean? Terribly fascinating, certainly not beyond your capability. Okay, the last area that we're going to talk about.
We're running out of time, so maybe we want to get a couple questions too.
Sure, this will be insanely quick.
Great.
The last area we're going to, does anybody have any questions? I'm happy to take them.
Yeah. Keep going.
The last area that we're going to talk about is immigration. Now, immigration is a terribly complicated area of law. But like marijuana, with respect to sanctuary cities, I think you should think about anti-commandeering principles and preemption working together to determine what the state is preempted from doing and not doing. And it depends on what the state or local government's actually doing. Anti-commandeering is going to say that you can't force a state to enforce federal law or enact federal law. And what they are doing beyond that may be preempted. The one difference with immigration that you need to think about is that immigration is arguably an area of peculiarly federal interest. Remember when I talked about the Articles of Confederation and the ineffective federal government and the dynamic that states were overstepping the federal government in areas like foreign affairs? Well, the Constitution gives the federal government much stronger foreign affairs powers than it had in the Articles of Confederation. Warning, I'm not going to take this turn. This is where the great Miami River is coming up. There's no immigration power in the Constitution. There's a naturalization provision. Immigration isn't naturalization. But there's a history. Let's just say, assume for the sake of argument, that the federal government has particularly important power in the realm of immigration under American law today. In the Apex, this is just terribly fascinating. The Apex Supreme Court case governing the extent of federal power, that dynamic I just mentioned, and preemption here is a case from President Obama's era that's on the complete opposite ends of the policy spectrum from the current dynamics going on in our country. So some of you may remember this, but during the Obama presidency, the state of Arizona was frustrated with federal law and federal immigration enforcement. And so they said, we're going to do something about it. Terribly understandable. And the federal government sues them and says, you can't do that because immigration's our domain. Now, this language I pulled out, this is the key language from, I think, the dual key language is arguable, but this gets to the heart of the matter from Justice Kennedy's opinion. And I think it speaks for itself. But fundamentally, look, national government has significant power to regulate immigration. I think his language is incredibly tactically intentional there, not to say exclusive power. So I don't know, where's the limit? Well, we'll deal with that another day. But he doesn't say exclusive, but it's very powerful. And the state may not pursue policies that undermine federal law. An interesting point about this case, the state of California joined several other states to argue on behalf of the federal government that the federal power to regulate the deportation of undocumented immigrants is an exclusive federal concern. So they're saying, Arizona can't do this, guys. It's an exclusive federal concern. Fast forward to this year. The Trump administration, you know, with the Trump administration, there's been a flurry of administrative cases. It's kind of hard to keep, or excuse me, immigration cases. It's hard to keep up with them. But recently, in the Ninth Circuit, we had the United States versus California. And California was instituting laws to prevent cooperation with the federal government on immigration. Now, most of those were upheld, and the Solicitor General of the United States recently appealed to the Supreme Court. But I think what's interesting, and this makes a larger point that I have to my meta point. California, if the court takes this case, California is going to be before the Supreme Court of the United States with a fundamentally inconsistent position that it had before. Where before it said, hey, Arizona, you can't do this. You can't solve this problem and take it on yourself because this is an exclusively federal domain. And I looked briefly at their what's called amicus brief in that case, and they said, they even italicized the words. Court, and it's not just the what of federal immigration law and deportation, it's the how. They italicized the words. So they're going to be standing before the court again, and there's a fundamental awkward dynamic about, hey guys, is this exclusive federal domain or it's not? Now, in the art of lawyering, they're probably already thinking about it now, an argument for why we're really not inconsistent, but they are. And the larger point with that for all of us is that the reality is they're on both sides of the issue to get what they want. That's not new. That's human nature. Can anybody, and it underscores the importance of the rule of law that we're fighting for. It's your law. It comes from the text. It just is what it is, and we hold on to that. Can anybody tell me, do we have any questions?
We've got one online. You want to take it now?
Let me take it, and then I'm going to finish. I'm going to finish with I'm going to finish something else. Good.
Great.
Yeah.
We have somebody online, going back to the Second Amendment, asked the question, what is the definition of a militia? And if it were me, I would probably ask, what was the definition of a militia? But interested to hear what you say.
Well, I think that if I remember the case correctly, and I actually have it, but it'd take me a little bit to dig it out, Justice Scalia may define that. The answer let me back up and make a point. The answer is what's material is what that meant at the time they put the words on the page. So it's possible, I honestly don't remember from the opinion if Justice Scalia defined that, if there was discussion around that. It wasn't ultimately material for the existence of the right to have a handgun in your home for self-defense in the case of confrontation. What California is doing and the importance of the rule of law isn't new. And we've been dealing with this since the very founding. Last point. The Constitutional Convention. And I talked about one person, one vote, and how special that is, and your vote counts as much as the president. The Constitutional Convention, when we were talking about what's going to be the composition of our legislature, there were two plans put forward. One was, and this is why we have two houses now, a House and a Senate. One of the plans was, some states are bigger than the others. Some interests, back to my point, are we too diverse to be one? We got the farmers in the South. We've got the manufacturers in the North. Our states are different sizes. We have different interests. We should just have all the same amount of representatives so that there's not an imbalance of power and some people can't just dominate and control the others. And then the other group said, no, we're all equal. Let's have proportional representation. Does anybody remember what the name of the plan for the proportional representation was? It was the Virginia plan. Can anybody tell me what was the capital of the Confederacy for the majority of the Civil War? Where was it? Yes. Virginia, big bellwether state of the Union. Of course we want the majority to control. We're the biggest. And they thought that Ohio, Indiana, Illinois, Minnesota would vote with them because they were agrarian. The Southerners did. So they want, hey, we're going to control. We're going to be able to protect what we want and control. But they didn't. And so when the Union started to pull apart from those dynamics, all of a sudden you have a civil war. And I like to look at the Civil War in secession as fundamentally the great switch. We can't control with the numbers anymore. The people in Pennsylvania are breaking up slavery through their own democratic processes. So now we got to come up with all kinds of arguments about why us as the minority are being oppressed by the majority, and we're going to leave the country, and it almost tore our country apart. Fundamental point. This is not a new dynamic. The rule of law in America is not just what's the substance of a statute. It's terribly important. The rule of law, the law in America, the Constitution codifies that you decide also governs the structure of our country. And while I'm a big believer in popular sovereignty, because I didn't matter for 10,000 years, my mom didn't matter for 10,000 years, we don't have unmoored popular sovereignty in America. And that's a bad idea. Cite the French Revolution. The founders were brilliant, and they created what sometimes folks refer to as ordered liberty. I like to think of it as institutional populism. That who decides? You decide. But you decide through a process and through representatives that's governed by a document that has text that's yours, and that's the law. And so the rule of law, we need to hold on to it. It's the text. It's our law. It just is what it is, and we need to hold on to it because people are always going to be on every side of every issue, and that shouldn't surprise you.
Let's give our guest a big round of applause. I think this class should be required watching. Anybody have a quick question they want to ask? We'll take a couple. We do not have long though, so let's start right here. Say your first name, please.
Hi, my name is Monique. I'm with an organization called Southwest Ohio for Responsible Technology. My neighbors are members also. I'd like to know what your thoughts are about 5G and how this is being forced on us. I've got all kinds of packets here and papers about Americans that are fighting 5G. A lot of people that we talk to don't know anything about 5G.
I need a question.
Yeah, how do we stop this? How do we get it so that we're being heard? I mean, right now in Louisiana, they unanimously voted to stop 5G, calling for the study of effects on health and environment before 5G is launched. Pennsylvania lawmakers canceled a vote on proposed.
I'm going to have to stop right there. I'll let you answer the question.
With respect to the benefits of 5G, yay or nay, and when I think about it separate from the question of law, I'm happy to tell you what I think potentially later. For purposes of what we're talking about here, text, does it pass according to what the text says and how it does? If it does, it's the law. So you find a way to stop it if you don't want it to do it before it becomes the law, at least in my mind, because I think there's a moral obligation and a legal obligation. Once it's the law properly, it's the law.
Next question.
Yeah, you were talking about medical marijuana and the Ohio law. That and sanctuary cities, are those examples of states using nullification?
Rhetorically, I don't know, maybe, but they would say, look, you can't force me. It depends on what they're actually doing. If they're doing something that goes beyond the scope of the anti-commandeering principle and it conflicts with federal law, depending on the specific area of law, if it's immigration, given the peculiar nature of it, it's probably preempted. So in that sense, if you want to look at it like it's nullification, they still can't do it, just like the South couldn't do it. But I think that's probably more rhetorical than a legal analysis that would be used at this point.
Hi, Joe. My name is Bill. A question again about medical marijuana, and your example is pretty interesting. Seems like we don't have the federales crashing these medical stores and arresting people. So it seems to be okay in terms of the common person using medical marijuana. How about if you're a federal employee and you're prohibited from using illegal drugs, but you have a medical need and you're prescribed it? Is that person in trouble as a federal employee if they use medical marijuana?
This is at the fault line of a ton of incredible, interesting questions. The Congress has even, in its spending bills, has been limiting federal enforcement of the marijuana laws. So they're not aggressively doing it, but that's a separate question from whether or not under force and effect of law, the state law might be preempted. What a federal employee might do. Another interesting question is employment law. You've got, is it a reasonable accommodation where you got to let people smoke medical marijuana? The federal agencies, and it's not impossible. They're going to say, yeah, this is a reasonable accommodation. You got to do this. I don't see ultimately how they could end up doing that because the statute says to the contrary. And I don't, no matter what we've allowed thus far with respect to agencies in America, I don't think that dog should hunt, at least, as long as there's a statute there. And it's still, marijuana is still a Schedule I drug. Technically under the statute, I think the Attorney General can change, the agency can change the designation, but as long as that's not the case, I don't think the agency, it's a basic, even today, it's still a bedrock principle of agency law that the agency can't transgress its statutory mandate. It does still constrain it.
Right here.
Hi, good presentation. My name is
Thanks.
Paul.
Thanks, Paul.
I'm curious about the agencies that you referred to, because reading Article 1, the legislature has the responsibility for creating law. Yet the agencies both create law, write the law, enforce the law, and adjudicate the law. Totally unconstitutional. So if you look at absolute law,
Yep.
it is an absolute law corrupts, absolutely. And that is what the agencies, it should be, of course, challenged, but the courts won't touch it.
I think, and I'll just do a quick answer to this, but I think, again, smart man, you're on a really interesting fault line in American law, particularly with the growth and the winning progress of freedom with these principles, is that where do these guys aren't in the Constitution? And you just mentioned Article 1 says all legislative power herein granted is to the legislature. I think you might see some agencies excess curbed. I don't know. I think that the practical point to stop it is the parade of horribles. What's going to happen if we do it? We're dependent on these guys, but there are tens of thousands of policymakers in Washington, D.C., and you and I vote for 4 of them. A president, 2 senators, and a congressman. I can't be the only one who thinks that's crazy. So it is possible that you could see some curbing of what agencies can and can't do in the future. But right now, you're right. That's a tension in our law for sure. But allowed under Supreme Court precedent.
Question right here.
Okay, I'm Tom. I'm glad that as you're saying that it seems that the text is being relied upon more in legal decisions and so forth. How is this happening? Because my impression is that the legal faculty of law schools is pretty left-leaning, and a lot of them are more looking for they seem to be prejudiced towards outcomes. Social justice comes to mind and other things like this.
Well, simple answer, the Federalist Society. And the Federalist Society, like I said earlier, has been essentially waging a war of ideas in the lawyer class, and that includes on college in the academia for these principles. And I will say 2 points. One, we can't do it alone. To take this to the last full measure for our country, it can't be an elitist movement. It can't be, because it's fundamentally the people saying, we want our law according to the text, because it's our law to be enforced, to be read, interpreted, enforced, and applied according to the text. It's got to come from the people. With the one point being, the judiciary is terribly important, and people have an awful job, terribly hard job, even in the federal judiciary. And even the people I disagree with have nothing but the utmost respect for who they are and what they do for us. But the people at the same time are well within their rights and should demand and hold everyone accountable to the dynamic that, hey, our law, the law around here is what the people's representatives put on the page when they put it there. And anything less than that isn't progress. It's regress, and it ain't forward, it's backward. And no one needs to apologize for that. It's just on the right side of human history.
Let's thank our guest again for coming in. What a great conversation. Thank you so much. So I guess I had to ask about the California, that's fine. The California decision, was that Attorney General Kamala Harris who handled that?
She was on the amicus brief.
Was she?
Yep. In 2012, saying it's an exclusively federal. She was on that brief.
Interesting. What a great topic to kind of get your head going tonight. Don't go home and stay awake all night thinking about this, please. But we thank you so much for coming in. And I know I threw some of those curveballs about marijuana and guns to our friend and board member, Joe Platt, who helped arrange this class. Let's thank Joe. What a great class. He's in the back. I also want to recognize Supreme Court Justice Pat Fisher, who's in the back, who has been a friend of and has spoken at Empower You before. And I want to apologize on the 5G question. I find that to be a very interesting topic. And if we can do a mini 15-minute session on it, I'm all on board. So I didn't want to cut you off, but we just try to have a vow to kind of end our classes semi on time. So, hey, Tuesday night, 6 empowered citizens are going to speak on issues they think that are important. Wednesday, is it Wednesday night? Oh, Tuesday night's the election, so we pushed it to Wednesday. Thank you, Jude. It'll be Wednesday night. I hope you'll come and listen to them because I think you'll learn something. Thank you very much for coming. Have a great night.